This is the CitizenLink Report.
If you find our insights helpful, would you support our video efforts? Your gift of $25 or more goes a long ways. Covers the crew, lights, cameras, all that. Just click on Donate. Thanks from all of us.
A 5-4 decision at the U.S. Supreme Court reaffirms that family-owned corporations have religious rights. This is the CitizenLink Report. Hi, I'm Kim Trobee, and I'm joined today by Bruce Hausknecht, legal analyst with Focus on the Family. Bruce, it's so good to have you here.
Hi, Kim.
Okay, we've been waiting for this one for a really long time. The High Court has been mulling over arguments in a case brought by Hobby Lobby and Conestoga Wood Specialties. These two family-owned businesses that have been built on religious principles went to court. Tell me why they decided to file a lawsuit.
Well, they were forced to. They were forced to choose between their faith and earning a living because the HHS mandate requires employers to include in their company health plans possible abortifacients, meaning contraceptives that could kill a new life that's being formed in the womb. They, because of their religious beliefs, could not comply with that part of the HHS mandate. And they had no choice because the fines, if they didn't comply, were in the multi-million dollars per year. Would have put them out of business almost immediately. So they and dozens of other for-profit companies around the country have filed suit. This case just got there first.
And Bruce, we need to clarify something. Hobby Lobby and Conestoga Wood weren't saying they were opposed to all contraceptives offered in Obamacare, were they?
Yeah, and that's true. And that's the misconception about this case is both companies have offered contraceptives in their health plans in the past. They just object to the 4 out of the 20 FDA-approved contraceptives that can terminate a brand new human being formed in the womb, and that was it. That's what the HHS mandate imposed on them, and that's what we're talking about is a coercion of conscience, not contraceptives.
Now, this decision came down on Monday. Help me understand what the ruling means.
You know, this is real easy to explain. There are essentially two big issues or questions that the Supreme Court answers. The first is, do you forfeit your religious rights when you go into a business, specifically a family business that is formed as a corporation as opposed to a partnership or a sole proprietorship? And the court said, no, why would there be any difference? No one's arguing that proprietorships and partnerships can exercise religion, but a family corporation ought to be able to anyway. They're run by people. The second issue that the court decided was simply this. The government had alternatives if they wanted to provide all 20 free contraceptives free to all women everywhere. They had alternatives to then forcing employers to do it against their conscience. It's that easy.
Now, there were literally hundreds of cases that have been filed over the HHS mandate. How does this ruling how will this affect those?
Well, they should fall like dominoes as we go forward. This case is not over. They have to go back to the trial court, and the trial court has to look at what the Supreme Court did. It may end very quickly with a win, and all of the other for-profit companies in lawsuits, I expect, will end the same way. And then we have all of the nonprofit religious organizations, everything from Catholic archdioceses to nonprofit, Bible things, Bible publishers, Bible producers, and formed as nonprofits, religious nonprofits. That question is slightly different, but the end result should be the same. Their conscience is being violated if they're required to produce things in their employee health plan that violate their conscience.
You know, there have been many cases as well of individual, like sole proprietors, people like bakers, photographers, who have said, I'd rather not photograph a same-sex ceremony because of my religious beliefs. We also have a baker in Colorado who has said, I'd rather not make a cake for a same-sex ceremony. Does this decision have any effect on those cases at all?
Okay, well, I'm going to have to answer that very carefully. The answer is it ought to. But I need to explain that the law at issue in the Hobby Lobby case is a federal statute called the Religious Freedom Restoration Act. That only applies to federal laws or actions by the federal government. all of these cases regarding wedding vendors, the bakers and florists and photographers, those were prosecuted or are being prosecuted under state laws like non-discrimination, public accommodations laws. Now, since it's a state law, it's not covered by RFRA. However, there are 19 states that do have their own versions of the federal RFRA. Because of that, in those states, those state courts can surely and ought to be influenced by what the Supreme Court said interpreting the federal RFRA. If so, yes, there could be some help on the horizon for Christian vendors and people of faith who do business in the wedding industry.
So basically, there is still a lot of work to be done when it comes to religious freedoms for Christians and for others in our country, but this was a really big win. It
really was. It really was. And I would encourage states that haven't passed their own RFRAs to follow suit and pass them as quickly as possible. The Hobby Lobby case shows and highlights the importance of having those on the books.
All right, Bruce, thanks so much. You always bring great information to the table, and I just appreciate you.
Thank you, Kim.
And thanks to all of you who have written us your thoughts and encouragement. We love to hear from you. Our email address is mail@citizenlink.com. That's mail@citizenlink.com. And please remember to pray for our nation and our elected officials, and stand tall and be heard.